had to unwind in subsequent proceedings in bankruptcy court under 11 U.S.A. 349, Section 349. That's not what is happening here. To me, that is the classic disrespect for the authority of this court. It is classic disrespect for the judge in the District of Columbia, who doesn't have the benefit of all this. And so what's the remedy, Your Honor? The remedy, whether you do it under 105 with the court's inherent jurisdiction, whether you want to find that Ms. Stone violated Section 521A3 in her failure to cooperate with the trustee in attempting to chill these sales, or whether you find under 362A3 that she's seeking or she's violated the estate, that goes in favor of the estate by seeking to undo these sales transactions. There's no question she's in contempt of this court. She's in contempt of the process. She's in contempt of the law. And so what we would ask for today is that the court hold her in contempt and give her an opportunity to purge that contempt by mandating that Ms. Stone file in the district court case the orders and other pleadings from this case that provide the roadmap to any judge not to waste their time. And what I mean by that is the findings of fact and conclusions of law that Your Honor rendered in the real estate adversary, supporting the rationale for the final judgment. Those two documents should be required to be filed in the D.C. Superior Court. The sale motion and then the 3 sale orders should be required to be filed over. So a judge can look at the record and say, oh, okay, so this is what all these complaints are about. Because otherwise, the contempt for the court in the District of Columbia is ongoing. And it wastes that judge's time not to have that material. So in my mind, those are the 2 main remedies. Your Honor should also assess sanctions and monetary sanction. And we would have a subsequent hearing or some kind of process for Mr. Tavis to put in the additional legal fees and if the motion to approve the settlement with Mr. Finstad, who bought the North Arnold Palmer property, is approved, those are additional damages that we would ask the court to consider.
Could I jump in for just a moment?
I'm going to let Ms. Stone speak now, but before I do so, Ms. Kelter, I just want to confirm that you are merely using your traditional court reporter and you are not recording this proceeding electronically. Can you please unmute yourself and confirm on the record that you are not recording this proceeding electronically?
Yes, Judge.
Okay, thank you, Ms. Kelter. Okay, Ms. Stone, it's now your opportunity to make your opening argument and respond to anything that Mr. DillWorth said. Please,
well, first I want to say that I've gone on the transcript several times to try to get gone on the record, gone on the purported record, and the transcripts never appear. So I'm very concerned about that because it appeared that there is no such transcript. So perhaps you can tell me who's actually recording this. Is this being recorded digitally? And why was I never able to pull up a transcript?
Right, so all of this information is available on the court website, Ms. Stone, but I'm happy to share the information
No,
with you.
I know it's there, but I'm telling you, I went and I followed the instruction and there was no transcript.
Okay. In order to have an actual physical type transcript of a proceeding, a party needs to pay for that transcript to be transcribed. Otherwise, it remains in digital form.
But it was said not available. It didn't give me the option to buy it.
Wouldn't mind. Let me finish, and then, of course, if you have any questions, absolutely ask them at that time. If you would like to have a transcript of any hearing, any party may pay the court reporter, the official court reporter, and I don't know if Ms. Kelter's on that list. I don't know. There is a list of court reporters that people can hire to transcribe the hearing. You can pay for the transcript and then get that transcript, of course, as soon as it's ready. For example, I had a Chapter 11 case where the